Thank you, Chairperson. Chairperson, the presenter during his presentation was saying that rapists are not normally people who were exposed to pornography. I just want to ask something. Do you want to say these people who are raping children looking at a video of porn, then after that say, let's try doing this? Are they not attracted by what they see in the video? Thank you.
Okay, I've said that it is the case that the majority of rapists in this country don't require pornography to go and do the terrible, horrible things that they do. Okay, we are all aware of what happened a few years ago with the rape of the baby in Newton. Okay, a 6-month-old baby was raped. Okay, and this kind of thing is atrocious, and government needs to stop this kind of thing. The person that did that did not do it because they saw pornography. They did it because of their social environment, because of the family setup. There's something like 20,000 babies that get raped. Okay, and none of it has to do with pornography. It has to do with these aberrant social individuals. The fact that they've got a poor psychological makeup, the fact that there's something fundamentally wrong with them, and we need to imprison these people. They don't require added stimulus. I gave examples. Okay, that's the case in Germany of someone who watched the film The Ten Commandments and went out and killed and raped women because he saw that film. Most of us think the film The Ten Commandments is a good film. It won Oscars. Then we should all be allowed to see this film. It's a film about religion. It's about some of the fundamental things that we think are right. Okay? So it's unfortunate that some people are so aberrant that when they see innocent materials, they go out and perform horrible, horrible things. But we can't go and ban those materials because of those antisocial, aberrant individuals. Thank you.
Thank you, Chair. With due respect, Mr. Oppenheimer, we're grappling here with the real issue of strengthening our provisions, both relating to virtual and real child pornography. Can you expect us to take it seriously when the existing legislation allows for virtual pornography, child pornography, and we are under huge public pressure to address that very issue? What common good, when we legislate for the common good, what possible common good can there be to allow virtual child pornography? Thank you.
Thanks, I'd like to address that. I think you said you're under public pressure. We're under public pressure to not have gay marriage in this country. We're under public pressure to bring back the death penalty. Public pressure is not a good excuse for instituting unconstitutional legislation. The Constitution is what we use to judge things. Okay. Let's look at public good. Let's look at, first of all, the harms that would suffer if we ban virtual child pornography. Right. No more Romeo and Juliet. No more Egon Schiele. No more Klimt. No more cartoons. There's a huge number of literature, Lolita, okay? There's a vast amount of materials which we think are good materials, which are outside the rest of the world which is being used, which we think are important things. We don't want to stifle expression in such a fundamentally disruptive manner, okay? The onus is on you to say why there's something wrong with virtual child pornography. It doesn't cause harm, no child gets abused, why is it wrong? Why are we prohibiting it? And I think this is something that is referred to earlier. This is about moral sensibilities. This is about disgust. This is about the fact that some people find this stuff offensive. And I agree. I think some of it is very offensive. I'm offended when I see that kind of thing. And other people are offended when they see interracial hand-holding, homosexual kissing, people wearing garish clothing. The rest of my paper deals specifically with regulation of offensive materials. And I think that you can do so. You can regulate that kind of material by saying it's only designated to certain areas, that we don't have virtual child pornography on billboards, that we don't show it on mainstream television, but we don't have to have criminal sanctions. There are lesser things that we can do. And I suggest that you look at these my suggestions in that area quite closely, because they're very rigorous and philosophical.
Okay.
Thank you.
Okay, can I give a CEO just to give a comment?
Mr. Oppenheimer, I was wondering if you are aware that in terms of the provisions of the Act, we at all times during classification talking about judge within context. We're forever talking about bona fide documentaries. We are talking about artistic ability, and so forth and so forth. We're talking about scientific research. So all these things have to be judged within that context. But secondly, looking at the country that we have, South Africa being South Africa, and the lack of sophistication that we have, which is in the majority. I think this is where the issue of public pressure comes in. Would you say really people would be able to distinguish? You've seen visuals. There are times when it is very difficult for you to say this is real and this is not, unless you go into an investigation to say this is real and this is not. And looking at the system that we have, would you say in your opinion, we have that kind of justice system that would be able to put resources into that kind of activity to ensure and just check what we are talking about, whether it's real or virtual. Thirdly, what would you say to the issue of desensitization and desexualization of children? And are you honestly saying there is no sensitization to that effect?
Okay, I'm going to look at three different things that you addressed. Okay, first of all, you stated that you're looking at artistic contexts. Okay, I'd be very happy if you were. I can read to you where you don't. Okay, the X18 classification shall not be applied in respect of bona fide, scientific, documentary, literary, or except in the case of Schedule 1 which is child pornography, an artistic publication. Okay, so you specifically exclude artistic publications. The mic's not working, right? Okay.
Now we can speak again. Censorship.
Okay. Like you have a booming voice. Okay, so you specifically exclude artistic contexts. Let's put that out there. It's in the Act, you specifically exclude it. Okay, I'm happy that you look at other things like, you know, the political, literary, etc. Okay, but you exclude artistic things. Do you have a copy? Turn to page 6. Read Schedule 5 and Schedule 6. This is in the Act. This is in the Act. The amendment is affecting the Act, right? So you can change it. I'd be very happy if you could include artistic things. I think there's a problem with doing that though. I am very wary about protecting real child pornographers that say this is about art. And I don't think we should do that. I don't want someone to have that they can stand up and say, well, the real child pornography film that I just made is art. That's really a serious problem. There's children being abused, and the fact that it is art doesn't matter. It's abuse of children. Virtual child pornography, on the other hand, doesn't abuse children. That's why the distinction is valid. So I think it's important to understand why this is put here. I understand why there's a sense of saying we're not going to protect something for being artistic, even if it's virtual child, if it's child pornography. And you ought to uphold that in the case of real child pornography. Don't protect them for saying it's art. Okay, the second question.